What's up, guys? Igor Hernandez here. I'm one of the attorneys at Cornish, Hernandez and Gonzalez, where I practice injury law and first-party homeowner property claims. And today I want to warn you about something that insurance agents do often, and it's often enough that it creates problems for you when you're trying to get insurance and when you are in a situation after you have gotten insurance and you put in a claim, and now the insurance company wants to deny the claim because of something that your insurance agent did. And so what I'm talking about specifically is the following. You go get some insurance from an insurance agent. Typically, we're talking about an independent insurance agent, somebody who could source different insurance products from different companies and give you a quote and then sign you up with the insurance company of your choice. What happens often is the following. You go get an insurance quote from an agent. You say, hey, I'm buying a new house. I'm going to need to get property insurance, whatever the case may be. And then the agent asks you the different questions of the insurance application, because every insurance company pretty much has an application that you have to fill out, and you have to say certain things that they ask you, like how many claims have you had in the last 5 years, how many claims for water damage, whatever the case may be. If it's a car accident policy, it usually asks you if you've been in an accident within X number of years where you've been found at fault and things like that. Now, here's where it gets complicated. A lot of times the agent is looking to sell you a policy because they make money, but also it's not necessarily something that they're doing with a bad intent. Often they're trying to get you the best deal possible. So the agent knows from experience, like, hey, if you put down in your application that you've had 3 accidents where you've been found at fault over the last 3 years, your rate is going to go up. The insurance company is going to want to charge you more money to be able to insure you. So instead of doing that, don't worry about the fact that you had 3 accidents in the last 3 years that you got found at fault for. We're going to go ahead and just put down that you've had no at-fault accidents in the last 3 years in the application. It's not a big deal. Don't worry about it. I do this all the time. It's going to get you a lower premium and things are going to be good. Well, that's not true. That's not accurate. What happens is twofold. Number one, anytime that you fill out an insurance application, you're doing it under penalty of perjury. So you're committing a felony if you put down 0 car accidents when in reality you know that there were 3 car accidents that you were found at fault for in the period of time. But putting that aside, because that's on the criminal side, on the civil side of things, how it can affect your claim is, well, okay, cool. You put down 0 accidents when in reality you had 3 accidents. As a result of that, the insurance company offers you a lower premium, a lower rate to insure you. You're like, great, that sounds fantastic. I have cheaper insurance now, that's awesome. Life is good. Well, then you get in a car accident, and then you put in a claim with the insurance company. Let's say you have uninsured motorist insurance, and it was a bad accident, so you are asking for a lot of money. Well, the insurance company is going to do what's called post-claims underwriting. Basically, they're going to go back and they're going to make sure that the application that you filled out 3 years ago was truthful. And then they're going to find out that you had 3 accidents when you had put down 0 accidents. And then what they're going to do is they're going to void your policy. They're basically going to say, look, I'm giving you back the money you paid us, the $3,000 or $1,000 or whatever you paid us over the last 3 years. Here you go. I'm giving it back to you. And I'm not covering this claim. So basically, in essence, you were uninsured at the time of this loss. We're not paying you anything because you lied on the application. Now, can they do that? Yeah, they can definitely do that. Under Florida law, there's something called a material misrepresentation defense, which basically voids the policy. It makes it so that they don't have to pay you, even if the policy was in effect, they would have to pay you. Meaning, even if the policy triggers, even if there's an accident that's somebody else's fault and your uninsured motorist would cover it, or even if it's an accident that it's your fault and your bodily injury coverage would protect you from liability from the other driver, they don't have to pay it. They don't have to defend you. They don't have to do anything. They'll do the material misrepresentation defense. They will have to prove that A, you lied in the application, meaning that you had 3 accidents when you in fact put 0. B, that the thing that you lied about was important enough that they would have either insured you at a higher rate or not insured you at all. And if they can prove those 2 things, then basically they win and they don't have to pay you anything and they don't have to cover you. So in reality, because you lied in the application, because you put down something in the application that was not true in the beginning, here you are 4 years later without insurance, which is the sole reason you were paying for insurance to begin with. Now here's the kicker, right? the insurance company's not going to do this review usually until after it has significant exposure, meaning until after it has been called to pay a claim, which means the following. You could go 5 years paying for insurance and they're taking your money and you have no claims and life is good. And you're basically paying them for nothing because the moment that you put in a claim that needs to be covered, they're going to try to find out if your application was accurate and they're going to void your coverage. So it's a win-win situation for the insurance company. They get to collect your money so long as there are no claims, and they basically don't have to pay you anything. They're just taking your money. And then in the situation that there is a claim, they get to evaluate whether the claim is something that's going to put them in the red, meaning whether you're going to get the benefit of your insurance. And if the answer is yes, they're just going to void your coverage and pay you nothing. So it's a win-win for them. It's a lose-lose for you. I've seen plenty of situations like this develop. I've been in situations where an agent has suggested to myself as a person looking for insurance that that's a viable way to do it, meaning like, oh, don't worry about it, just put zero there or don't answer that question or whatever, and I've been the one to have to tell the agent like, yo, listen, that sounds cool, but I know how this works, right? Like I'm a lawyer, so at the end of the day, I've dealt with a lot of these cases where you put zero on this and then you may as well not have insurance, because what's going to end up happening is when you need the insurance that you're paying for, they're going to come back and say that you misrepresented the application and they're not paying anything. And you know what? They're right. You should not lie in an application for insurance. It's not only a felony, it also is not cool. You should be truthful in the application like anything else and get your insurance and be able to sleep at night knowing that when a loss happens, at least you'll be legally entitled to bring a claim and legally entitled to pursue that claim to the full extent of the law under the insurance contract because you have done nothing wrong. So anyway, guys, that's it for now. I hope you find this helpful, and I will catch you again next time.